Welcome back to the OMB Law Board. I'm Simon Bennett, partner with OMB Solicitors. And for part 2 of our family series, I've got Abbi Golightly, family law partner, Queensland Law Society accredited specialist in family law, on the Doyle's Guide, highly accredited family lawyer. Welcome back, Abbi.
Hello, Simon.
Thanks for coming back.
That's okay.
Glad we didn't scare you off in the first time.
No, I can talk about this all day.
Okay, well, I don't know if we've got all day, but we'll talk about it for a bit. I wanted to talk to you today, however, about this highly emotive topic, and I think it's, from the outside in, the most difficult area to deal with in family law, which is parenting.
Yep. So family law as a general concept, emotional, difficult, stressful, children's aspects of it is that, exponentially harder for all the reasons that you would assume it to be. These are your children. Nothing is more important than them, and trying to sort out what happens with their living arrangements when your world and their world has turned upside down is incredibly difficult.
Yeah. When I think about, that relationship breakdown, the bit that actually gives me anxiety is losing time with your children.
Yeah.
How do you deal with that?
Look, it's difficult because you need to guide people through a really difficult first stage in terms of not knowing where things are going to lie, whether people have separated under the one roof, which makes things practically easier. But then what happens when they've got separate residences and where children are going to live, how much time they're going to spend with the other parent, who makes decisions about what. There's a million different variables that need to be considered, overriding with the concern of what is in their best interests, taking into account safety issues, practical issues, who's living too far away from each other.
Can I just drill back on that for a
Yep.
second? Because this is the trigger, I think, for me, is in their best interest. When you're talking about their best interests, let's be clear here,
Children's.
the children's best interests.
Yes. So
What about the parents?
No, parents' best interests, not something I'm particularly concerned with, and neither is the Family Law Act nor is the court. There is a misconception, and we often hear people say, well, what are my rights? Or, and that's a parent, a grandparent. Parents and adults have no rights. Children have rights. The children have a right to a relationship with both of their parents and all manner of people who are important in their lives. So grandparents, aunties, uncles, siblings, those sorts of things. They have those rights, but parents have no rights.
I think that's really important, particularly for our viewers to start to think about if you are either going through this situation or considering this situation, is that the rights we talk about in a family law context are not your rights. They're the rights of the children, and the court is always doing what is in the best interests of the children.
Correct. And what that is and how we get to that decision is a multi-layer of variables and considerations, recently sort of truncated and shortened by the amendments to the Family Law Act, which started just over a month ago, really new, really fresh, arising from the 2019 review of the Family Law Act and public inquiries and things like that. So whilst the factors have been reduced from 20 odd to about 6 now, the overriding best interest consideration remains there. So it is what is in the best interest of the child or children, and what is primarily in there for their safety, to minimise their risk to harm, and that's physical, emotional, psychological, all manner of harm. And we run through those factors and we balance all of the different competing proposals and considerations and try and reach an outcome that is in their best interests so that they have that meaningful relationship with both of their parents.
Having said all of that, you're still acting at OMB for one of the parties.
Yeah.
How are we undertaking the representation of that party to ensure, firstly, the time with their children occurs?
So it's important that we speak to clients about what's brought them to this point in terms of if there is any concerns about domestic and family violence, how we mitigate those concerns, as well as what's the history of the care arrangement. So what each parent did during the relationship, and that's from their perspective. And don't forget, your perspective and the other people's perspective will often be completely opposite. You've got to kind of wade through the different competing perspectives and see realistically what each parent did. We speak to them about that history, those concerns, and then what do they see the future like for their children? What do they genuinely believe is in their best interests? And then break that down as to why. Because sometimes there are concerns that motivation around parenting arrangements are for different reasons other than best interests. Not often, because I would promptly bring an end to that one. But it's about getting that background and then advocating for the client's consideration of what's in the best interests of their children, gathering evidence from experts and independent sources, schools, daycare centres. There's family reports and different ways of gathering external information. And then we put all of that together and then fiercely advocate for what our client thinks is in the best interests of their children.
Okay, now, full disclosure, I'm not up on the latest on the family law stuff, but is there a presumption of 50-50 time?
There isn't now explicitly, and there actually never was. Again, a misconception.
We hear that a lot though, don't we?
A lot, so many times saying, well, I'm entitled to 50-50, or there's a rule that says I have it. There never was, with the changes that came in 2006, were those tranche of changes. There was a requirement for the court to consider equal shared parental responsibility. That's a whole separate conversation. And if there was equal shared parental responsibility, a requirement to consider equal time. So requirement to consider, as opposed, people take out the consider and just
So
go requirement.
Out of context a little bit, but
out of
that's,
context.
I think our viewers and listeners
Absolutely.
would love to hear the explanation around that because, I'm in the law, but
Yep.
I've heard that a lot as well. And
So yeah, it never was there. Now it's explicitly been removed in these May 2024 amendments to say that there is no presumption of equal decision making. So now we've taken out parental responsibility and talk about decision making. So that's all been removed. So the misconception, the misunderstanding, the confusion, and the understandable upset that being told that actually was never there and you don't have that right. That's all been removed from the Act, so that should give a little more clarity for people.
Okay. Can I direct you then to the second component that I consider, which is this decision-making concept? I mean, I want to know who gets to decide which school they go to and, all the other bits and pieces that goes along with raising a child. How do we deal with these day-to-day decisions?
There's so many big decisions that need to be made for children, particularly as they're in the early stages of their development, deciding what schools we're going to go to, religious affiliations, those sorts of things. They're your big ticket items. So they are classed within what we call long-term decisions. So decisions that are made that can impact the long-term future for children. And then we have day-to-day decisions. What time we go to bed, how much screen time we get, do we eat vegetarian, or those sorts of things. Day-to-day decisions rest with the parent with whom the children are spending time with at that point in time.
Okay.
Long-term decisions, there is, and I'll use that word presumption because that is there.
Yep.
In the Family Law Act, the presumption is that parents will continue to make those joint long-term decisions together and that they have to use their best endeavours to make those long-term decisions unless it is not safe to do so. So safety, again, the 2024 amendments are all about safety, ensuring the safety of children. So your long-term decisions made jointly if safe to do so. Conversations, text messages, emails. What school do we want our child to go to? Let's pop them on the wait list for this school and that school. Do we want to get our child baptised? Does our child need a non-emergency medical procedure? Tonsils.
Yeah, never ending, is it?
Never ending decisions. Those big ones, jointly made, we're safe to do so.
Okay.
The day-to-day ones by the parent who is with the child at that relevant time.
So not only highly emotive, but highly complex areas of law with heaps of factors.
Heaps and heaps of factors more. Even though, as I said, they've reduced them in the legislation, each factor has so many different ways of being interpreted and different, individual circumstances impacting how they work.
Yeah. And all the more reason why, our listeners and our viewers should be contacting the OMB Law team, and particularly the family law team for information and help with these things. I guess like any area of law, get in early.
Yes, get in early, get information, use that information to enable you to make sensible decisions to the best that you can, but informed decisions. And that's one of the big things that I speak to my clients about is even if you come to see us really early and I might not hear from them for 12, 18 months, 2 years, longer in some circumstances, but they've had that information early on. They've used that information to guide their decision making to that point, and now they're ready to proceed, knowing what the various steps are and what they do and don't need to do.
Absolutely. Information is power. And when I get asked about family law matters, I'm directing them straight to our family law team here at OMB who have got that information. And if they can help you, I think that is something you should be looking at sooner rather than later, because often when things happen, it's too late.
Yes, absolutely. Early intervention, early access to information, no obligation consultation, gather information, take it away, process it. And when you're ready, OMB Family Law are here for you.
Fantastic. Well, thanks for having a chat to us on the OMB Law Board today, Abbi. We really appreciated your time. The information you've shared with us has been really interesting, and I'm sure everyone's enjoyed it. So thanks for joining us again.
No problems at all.